Prior to the coronavirus outbreak, most workers never gave personal protective equipment or PPE much thought.
But now, with states such as Georgia and South Carolina and Tennessee opening up, millions of employees are questioning their legal rights. And joining us now to talk about it is our chief legal correspondent, Dr. Laura McNeal. Good to see you again. And let me ask you this. First off, do the employers, are they compelled to provide personal protection equipment for those employees going back into the workplace?
Yes, the Federal Occupational Safety and Health Act, which is referred to as OSHA, does require employers to reduce or eliminate any potential workplace hazards, which include possible COVID-19 exposure. So they would be required to produce PPE, personal protective equipment, such as gloves, gowns, the plexiglass that you see popping up in our grocery stores. So the level of protection that employees would be legally required to provide depends on the level of threat that particular job presents.
So do employers have to provide personal protective equipment?
They do. So it depends on the level of risk. So essentially under the OSHA Act, there's 3 levels of risk. There's high risk, which would include healthcare workers, individuals working with a morgue. Those employers would be required to provide PPE such as gloves, masks, and gowns, for instance. However, if you're at a medium risk employment job, such as a cashier in a supermarket, the employer wouldn't be, for instance, required to provide a gown, but they would be required to provide either, gloves, a plexiglass, some barrier of protection. But what's important is it's based on the level of exposure they might be at risk of being infected with.
And Dr. McNeal, let me ask you this. If I'm an employee, let's say in the state of Georgia, and I'm compelled to go to work, but I don't feel it's safe for me to do so, am I at risk for repercussions from my employer?
My heart goes out to those employees across the nation that will be starting work next week, and they are indeed afraid of contracting this COVID-19 virus. And yes, you can, if you feel that you are in imminent danger, is what the OSHA statute says, of contracting the COVID-19 virus because someone is known to be infected with the virus that's still in the workplace, you can walk out or refuse to go to work until the employer addresses your concerns. If you are fired or retaliated against in any way, you would have be able to file a lawsuit essentially against the employer for retaliatory discharge. So yes, if you feel unsafe and you're an employee going back to work, you can refuse to go in. But again, the key is you have to feel you're in imminent danger. So if you don't feel that you're in imminent danger, then you would need to file a complaint with OSHA, which is very easy to do. They have a real friendly online form. You just Google OSHA, O-S-H-A, and the complaint forms will pop right up. But what's important is there are laws in place to protect these employees going back to work.
And Laura, can an employee be forced to use PPE if they don't want to?
Actually, they can, because if not, the employer would put themselves at liability risk because they're not making sure their employees are using, again, the type of protective equipment to keep them safe. OSHA requires employers to maintain, to the greatest extent possible, a workplace that is free of hazards and any potential safety issues. So an employee who refuses to wear PPE can be either fired or disciplined for doing so.
All right, that's Dr. Laura McNeal, our chief legal correspondent. Thank you so much for the knowledge, Doctor, and we'll speak to you again soon. Have a good night.
Thank you.